Good morning, Dr. Sabri. Today, our Group 4 will present about Topic 4. It is Discharge for Contract and Remedies for Breach. A comparative legal analysis for franchise performance, breach on contract and available justifiable remedy in Malaysia. Group 4 have 8 members. It is me, Ko Jiswan, Nur Fatin Damia, Det Wan Jing, Nurul Ashikin, Teo Yong Ling, C.E. Heng, Kabipra, and Noh Hasha. My name is Ko Shen. First, I will present about introduction and problem farming. Contract law is important in Malaysia. Guns agreements in business and daily life. Main law is Contract Act 1950 and Common Law Bill 2020. Problem is parties sometimes do not follow contract. This led to dispute. Key issue is when does a contract end? What remedy can the innocent party get? Discharge of contract is mean that contract ends. Main type is performance, function, and breach. That's all for me. I will pass to next presenter to continue our group presentation. Thank you.
My name is Tang Jing. I will present the identification of legal issue relating to the discharge of contract and remedy for breach under Malaysian law. First, the primary legal issue focuses on how a contract can be discharged. Under the Contract Act 1950, a contract may be terminated through performance under Section 38, agreement, fraudulation under Section 57, and breach under Section 14. Next is fraudulation. This occurs when the performance of a contract becomes impossible or unlawful. And under Section 57.2, the contract will be considered void. The third issue is breach of contract, which include both actual breach and anticipatory breach, and this raises the issue of how it affects the innocent party. Finally, there is the issue of remedy for breach, where the innocent party may claim damage under Section 74, as well as specific performance, injunction, and rescission. In addition, there are several secondary legal issues. One issue is the distinction between fraudulation and breach. Although both can terminate a contract, they differ in terms of liability, and the issue is how court distinguish between them. Another issue is the limitation of remedy, including factors such as remoteness of damage, duty to mitigate, causation, and the certainty of damage. Thank you.
Hello everyone, my name is Fatin Damia. Today I will explain about 3.0, which is mode of discharge of contract. 3.1 Performance. Performance is the most common way a contract is discharged. It happens when both parties successfully fulfill all promise and obligations stated in the contract. According to Section 13.8/1 of the Contract Act 1950, party must perform or offer to perform their promise unless excused by law. 3. Performance means the contract must be complete exactly as agreed, including quality, quantity, and time. If performance is incomplete or incorrect, it may result in a breach of contract. The second is 3.2 Agreement. A contract can also be discharged by agreement when both parties mutually decide to end, replace, or modify to original contract. Under Section 63 and 64 of the Contract Act 1950, this may happen through substitution of a new contract, cancellation of the contract, or alteration of its term. Once both parties agree, the original contract is no longer legally binding. The last one is 3.3 Breach. Discharge by breach happens when one party fails or refuses to perform their contractual obligations. This allows the innocent party to terminate the contract and claim damage. There are two types of breach: actual breach, which happens when a party fails to perform on the due date, and anticipatory breach, where a party states in advance that they will not perform. This protects the innocent party and provides legal remedies for lost suffered. That's all from me. Thank you.
Assalamualaikum and hi, my name is Nur Hasha binti Omar Saifuddin. I will explain about frustration of contracts in Malaysia. Under Section 57, Subsection 2, Contracts Act 1950, a contract becomes void when something unexpected happens after the agreement and it makes the contract impossible or illegal to continue. But if it is only more expensive or difficult, it is not frustration. There are a few types of frustration. First, when the item in the contract is destroyed, like in Taylor v. Caldwell. Second, when the contract becomes illegal because of law change, like Metropolitan Water Board v. Dicker. Third, when a person cannot perform due to illness, like Robinson v. Davison. And lastly, when the main purpose of the contract is gone, like Krell v. Henry. In Malaysia, courts apply frustration very strictly. In case like Pacific Forest Industries, the court state that frustration only applies when the contracts become completely different from what was originally agreed. If it is only more costly or inconvenient, it is not enough. Even during COVID-19, courts still look carefully to see whether performance is truly impossible or just more difficult. Finally, the effect of frustration is that the contract automatically becomes void. Both parties are released from the future obligation. Under Section 66, any money paid may be refunded depending on the situation, to ensure fairness between both parties. So, frustration only applies in serious situations where the contract can no longer be carried out as intended. Thank you.
Good morning, Dr. Sabri. My name is Teo Lim. I will present about the breach of contract. A breach of contract happens when a party fails to perform their obligation without law firm excuse under Section 40 of the Contract Act 1940. There are two types of breach. First is extra breach, where a party fails to perform on the agreed date, such as supplier failing to deliver goods. Second is anticipatory breach, where a party informs early that they will not continue to contract. For example, a contractor cancelling a product before it begins. When a breach occurs, the innocent party may claim reminders such as damages, specific performance injunction, or rescission. In conclusion, when a contract protects the right of parties and ensures fairness in contractor relationship. Thank you.
Assalamualaikum and hi everyone. My name is Nurul Ashikin binti Ahmadi Jaafar. In this section, I will explain the remedies available for breach of contract under Malaysian law. First is damage under Section 74 of the Contract Act 1950. Damage are the most common remedy and are awarded to compensate loss suffered because of the breach. Malaysia Court apply the principle established in Hadley v. Bissendale, who only reasonably foreseeable loss can be claimed. Second is specific performance. This remedy requires the party in breach to perform the contract exactly as agreed. It is usually granted when damage alone are insufficient, especially in contract involving land or unique property. Third is injunction, where the court prevent a party from carrying out action that may violate contractual rights. Lastly is rescission, will cancel the contract completely and restore both parties to their original position before the agreement was made. Although Malaysian law provides several remedies for breach of contract, there are still limitations in practice. One major strength is that these remedies help protect innocent parties and encourage parties to fulfill their contractual obligation responsibly. This promotes fairness, accountability, and certainty in commercial transactions. However, remedies may not always compensate loss, especially in cases involving reputation, business opportunity, or unique interests that cannot easily be measured in money. In addition, remedies such as specific performance and injunction are discretionary remedies. This means the court has the authority to decide whether the remedy should be granted based on the fact of each case. Another issue is the difficulty in proving foreseeable loss and remoteness of damage, particularly in complex commercial dispute. Furthermore, transition contract principles sometimes struggle to adapt to modern challenges such as digital transaction, technology contract, and global business operation. Overall, the law aims to balance fairness with legal certainty, while the court play an important role in ensuring justice based on the circumstance of each case. That's all for me. I will pass to the next presenter.
Hi, I'm Kavi Priya Ramanjalam Naidu, and I will be presenting Section 7, the critical discussion and evaluation of Malaysian contract law on discharge and remedies. The Contract Act 1950 provides structure, but in my view, it prioritizes certainty over fairness, and the tension is worth examining. On frustration under Section 57, the code requires performance to be legally or physically impossible, not merely difficult. I understand this prevents parties from escaping penalties, but I would like to agree that it sets an unrealistically high bar because of businesses already facing genuine commercial disruption like a pandemic or economic collapse. This is a critical gap. On remedies under Section 74 to 76, the compensation principle is sound, but proving remoteness of damage is increasingly difficult. How do we apply 19th century computations test to disputes involving digital assets or AI-driven tools of supply chains? That mismatch right is concerning. This brings me to what I consider the most urgent issue, the systemic gap. Traditional principles were simply not designed for modern digital commerce. In my view, judicial flexibility alone is not insufficient. Malaysia needs proactive legal reform, similarly like how Singapore introduced targeted legalism during COVID-19 era. The framework is structured, but it is not the future. Reform is under urgent. That's all from me. Thank you.
Good morning to Dr. Sabri. My name is Si Heng. Now I will present about our recommendations. First, legal awareness should be improved so that people better understand their contractual rights and obligations. Second, contracts should include clearer force majeure clauses to handle unexpected situations such as pandemics or economic crises. Third, courts may consider a more flexible approach when applying the doctrine of frustration in exceptional cases to ensure fairness. Lastly, mediation and arbitration should be encouraged because they are faster, cheaper, and help maintain good relationships between parties. Overall, this recommendation can improve the effectiveness of Malaysia contract law. In conclusion, Malaysian contract law provides several ways for a contract to be discharged, including performance agreement, frustration, and breach of contract. When a breach occurs, the innocent party may claim remedies such as damages, specific performance, injunctions, and restrictions. These legal principles are important because they protect the rights of parties and ensure fairness in contractual relationships. Overall, the Contracts Act 1950 provides an effective legal framework for resolving contractual disputes in Malaysia. That's all from me. Thank you. Hi everyone, my name is Si Heng. Let's start the Q&A section. Now I will ask the question 1 and my group member Damia will answer. What does Malaysian law apply the doctrine of frustration strictly?
Assalamualaikum and hi everyone. My name is Nurfatin Damia Inshura. Today I will answer the question, why does Malaysian law apply the doctrine of frustration strictly? Malaysian court apply the doctrine of frustration strictly to protect contractual certainty and prevent misuse of the law. If frustration is applied too easily, parties may try to escape contracts simply because performance becomes more difficult or expensive. Under Malaysia's law, frustration only applies when the contract becomes impossible, unlawful, or completely different from what the parties originally agreed. Economic hardship or inconvenience alone is usually not enough. This strict approach helps maintain fairness and ensure that parties remain responsible for their contractual promise. At the same time, it balances the interests of both parties while preserving confidence in commercial transactions. That's all from me. Thank you.
Assalamualaikum and hi everyone. My name is Nurul Ashikin binti Ahmadi Jaafar. In this slide, I will ask question 2 and Hasha will answer. The question is, explain breach of contract and its effect.
Assalamualaikum and hi, my name is Hasha binti Saifuddin. I will explain breach of contract and its effect. A breach of contract happens when one party fails to perform their obligation without a lawful excuse. It means the party does not follow the agreement stated in the contract. There are two types of breach of contract. First is actual breach, which happens when a party fails to perform the contract on the agreed date. Second is anticipatory breach, when a party informs early that they will not fulfill the contract before the due date. The effects of breach of contracts are that the innocent party may terminate the contract and claim remedies. These remedies can include damage, which is compensation for losses suffered, or specific performance when the court orders the party to carry out the contract. That's all from me. Thank you.
That's all for Group 4 presentation. Thank you, Doctor.